All right. We will now call this oral argument session of the 5th DCA. Good morning. I'm Meredith Sasso. I apologize for the technical issue. I am joined on the panel today with Judge Nardella and Judge Wozniak, also of Orange County. We have one case set for this morning. It is case number 20-2531, CTCW Berkshire Club LLC versus CEB Capital Holdings 2000 EB LLC. Just as a reminder to the parties, this will be recorded on YouTube and streamed live. We'll reserve 5 minutes for appellant's rebuttal unless we hear otherwise. And with that, you may proceed.
Thank you, Your Honor, and 5 minutes would be perfect, please. And may it please the court. My name is Steve Griffith, and I represent CTCW Berkshire Club LLC, the appellant in this matter. Over a 4-day trial, the circuit court conducted a hearing to determine whether or not CTCW, the limited partner in this case, failed to provide the consent necessary for the general partner to refinance a loan at Berkshire Club Partners Ltd. Following that trial, the circuit court entered an award of damages in favor of CED 2000, and that award should be reversed for 4 reasons. First, it awards relief that was not sought under a theory of the case that was not pled in the complaints in this matter. Second, it awards that relief for the benefit of a non-party to the case. Third, it includes a provision for continuing damages that is not supported under Florida law. And finally, the evidence in the record does not support the damages award. This court should reverse for any one of the 4 reasons. But the first reason is the one that is the most straightforward, and it is the easiest one by which this court may dispense with the appeal in this matter. The judgment at issue on appeal awards damages that were not sought in the complaints and under theories that were not pled. Judge Sasso.
Can I interrupt you very quickly? The final judgment, which we talk about, provides 2 grounds for the award of damages that we allege, or that you allege, were not sought and were not pled. The first ground is that, obviously what you said, they were not sought, they were not pled in the First Amendment complaint. And you argue that in your initial brief. But the second ground raised by the trial court is the final joint pretrial stipulation. And the court cites Business Court Rule 9.1. Where do you address in your initial brief how the trial court erred in concluding that the joint pretrial stip was not an alternative basis to find they could award damages, that the court could award those damages they did not plead?
Right. So the joint pretrial statement is in fact one of the issues that was cited by the circuit court, and again, it's cited in the response brief by CED. That order that was entered by the circuit court is submitted by CED, does cite to that business court rule. That joint stipulation is one of 2 requirements of parties that are going into trial. Under Rule 9.1, the parties have to satisfy that includes some stipulations, and that also includes any exhibits and witnesses that are going to be identified. Now, the business court rules also require under 10.1 that the parties separately provide their pretrial memorandum with their legal positions on the case. Here, what happened was the parties, as part of the stipulation, simply stipulated that in fact CED was seeking damages. They are seeking damages. They were seeking damages, and they are. But there's no consent to proceed. In fact, when that filing was made, 2 of the motions that are at issue on this appeal, the motion for summary judgment and the motion in limine, had already been briefed before the court and were still pending at the time. And then, following that joint pretrial statement, we filed a pretrial memorandum, again noting an objection to proceeding on that basis. Then at trial, we actually objected on the first day, and then in the middle
I think what Judge Nardella is getting at, though, is as you referenced, that is a basis for the trial court's ruling. And of course, it is incumbent on the appellant to demonstrate reversible error in the initial brief as to each basis for the trial court's ruling. So you know, if we view it through the lens of appellate waiver, is it your position that was sufficiently addressed in the initial brief, or that it is not required to be addressed in the initial brief?
I actually think it's both, respectfully, because the brief as presented and the issues on appeal are whether or not the circuit court had the ability to proceed. And incorporated within the order was a rejection of certain arguments that had been provided as to the business court requirements. But the legal issues presented actually to this court are whether or not the court should have granted the motion for summary judgment on damages, which predated that submission, also whether or not the motion for directed verdict should have been granted, also whether or not the motion in limine should have been granted, and whether or not the objection to proceed to trial was appropriate. And so the inclusion of some reference to that in the order does not obviate the fact that these other issues are all on appeal, nor does it moot them out. And in fact, the overall brief, we think, makes very clear that we don't believe that the trial court, the circuit court, had the ability to proceed in this matter on any basis. And we cited a whole series of bases for that. When that issue was raised on appeal in opposition to us, obviously we addressed it as we did in our reply brief. But we would respectfully submit that there's no waiver because it wasn't raised in the original appellant brief, because we identified the issues on appeal, the rulings that we thought were appropriate, including the ones that would allow this court to dispose of the circuit court's ruling through a reversal. Because in the Doda Panini case that Your Honor wrote for this panel, Judge, you noted that although that was a divorce proceeding, the procedural issues there were almost identical to what we have here. In that case, a husband opposed the request for a wife to get a temporary restraining order to freeze all bank accounts. And in that particular case, the court said, no, we're not going to freeze the bank accounts, but we are going to require that the wife's name be added to the bank accounts. This court reversed, and the panel cited three observations that are critical to the ruling here. First, courts lack authority to award relief that's not been pled in the complaint. They just lack it. It doesn't exist. That relief and that ability and jurisdiction of the circuit court to proceed does not exist. And that's true even when there's a generic request for relief, such as all further relief as the court deems appropriate. Similarly, this court in Doda Panini noted that the parties can agree to try issues by consent and expand the relief to which a plaintiff may be entitled, but of course there's no evidence of consent here, which I'll mention in a moment.
And so it's your position here that the reference to damages and the pretrial stipulation was not sufficient in order to meet the pleading requirement below.
That's correct, because the pretrial stipulation simply states that CED is seeking damages, which is factually true. I've said it here today. That's not a consent that we proceed in that fashion, and there's no dispute that that's what CED was trying to do. At the time that that was filed, and on 2 instances prior and on 3 instances post, we made clear in the record, we moved to the court in writing, we moved the court orally and said, Judge, you cannot proceed here. With all due respect, it's a violation of due process. The court lacks jurisdiction to proceed. And in Doda Panini, all the husband's attorney had to do was in a single sentence in the closing argument say, we're here on the freezing of bank accounts alone. We're not here on anything else, and the court rightly concluded that that was sufficient to find that, in fact, there was no waiver, there was no consent to proceed to a trial in that regard. Here we had
and this is a little different, obviously, because it was certainly referenced and requested and discussed and significantly litigated below. So this is more of the significance of the technicality, right? And technicalities are legal issues, so I'm not suggesting that a technicality wouldn't serve as a basis for reversal, but certainly there was discussion of the damages below.
Well, yeah, and respectfully, I may disagree with the term technicality here, because recall that the circuit court tried the issue of whether or not the limited partner failed to consent to the permanent loan being refinanced and then awarded damages to the general partner for it. No one can credibly say to this panel that that theory of breach of contract is in the complaint anywhere. It's not. No variation of it is there either. The complaint is very clear that it seeks breach of contract because the limited partner did not transfer its equity interest to the general partner. And then it seeks one thing. It only seeks specific performance. There's no reference to damages at all in the original complaint. The amended
Griffith,
complaint,
if I could interrupt you, the summary judgment that was before this court previously, that judgment reserved jurisdiction to award damages, correct?
it did. That's
and
correct.
where did that come from? Did the trial judge just come up with that out of thin air, or were the parties arguing it at that point? Where did the trial judge get that from?
Both that order and, candidly, the order that was signed here that's on appeal now was drafted and submitted by the plaintiffs. The Orange County Business Court's procedures are that at the close of the hearing, both sides are permitted to submit proposed judgments, and the judge signs one of them. And so, for instance, the damages award here that we're on today 4-day trial closes. He requests proposed judgments be submitted before any transcript is prepared. The one that was proposed by CED is signed. Without regard to the testimony or anything would be our position with all due respect to the lower court. And
was
so
there a motion
draft
for rehearing? Sorry, Judge Sasso, just a follow-up question. Was there a motion for rehearing filed either for that summary judgment or for the final judgment?
There was not a motion for rehearing filed. We took our issues up here at the 5th DCA, both on the original one and then also here as well, as we're, I think as we all know, permitted to do. But we did not do a motion for reconsideration at that time before the Orange County Court. Judge Sasso, I think you may have had a question.
Yeah, I think you're, this might dovetail into your next argument, but if it had been properly pled, let's put pleading issues aside, if it had been properly pled, is this a category of damages that CED could have sought in this action?
If CED had pled in its complaint that it was seeking breach of contract against the limited partner for a failure to consent to a loan transaction in fall of 2018, that's what the whole case was about. And if it had requested damages in that regard, then the primary issues on appeal today wouldn't be here. There's no question about that. And in fact, if we had consented to that trial, then that would have been another story too. But the reason we didn't consent is that, recall that the timing here is that this was revealed to us in an expert report after the pleadings were closed, after the deadline to amend was done, and as discovery was closing. And in fact, the evidence that this claim had been transferred from the parent company to the plaintiff in this action, that was not revealed until it was in opposition to summary judgment. The first time I was able to question the witness, Brian Spear, about that fact, the core fact in the case about standing, was actually a trial because discovery was closed. It was done. It was revealed in response to the summary judgment that we filed. And so there would have been great prejudice in proceeding even if the case had been actually pled correctly. Now, of course, if it had been pled correctly, we would have done discovery on those points. But Your Honor raises another good point.
Was there ever, below, and I want to make sure we get to the standing argument before your time expires, but was there any request below to either extend discovery or for additional discovery that was denied? Anything like that might play into this due process argument that you're making in the context of the pleading argument?
There was a request to continue the trial shortly before the trial where we cited this issue as well as the other logistical issues associated with trying the case remotely. That was denied.
And that hasn't been challenged on appeal? That
specific motion for continuance was not raised on appeal. It was not. But that is in the record.
Can you address then the standing argument that you've made in your initial brief?
Absolutely. And, what I would note on the standing argument is that there's one plaintiff in this case. It's CED 2000. It's a separate legal entity. It's got its own articles of organization. It's in good standing with the Secretary of State. And there's a separate entity, CAP 16, which is also in good standing. It's got its own articles of organization. It's got its own membership. It's undisputed that CAP 16 is the entity for which CED 2000 seeks to bring its claims here today and did so in the circuit.
So what should we make, in that regard, what should we make of the trial court's finding that they're essentially one and the same, that CAP 16 is mere conduit? Is that a legal finding as to the basis of standing? Was that a factual finding that doesn't play into the standing argument? How should we view that finding?
Well, I would respectfully submit that the finding is correct under the law. And in fact, as we look at the briefs, there's no case that suggests that we can conflate those two entities for purposes of standing here today. The argument that CED relies on is this argument of assignment, that Brian Spear on behalf of CAP 16 assigned to Brian Spear on behalf of CAP 2000 through his thoughts, no oral conversation whatsoever, the ability to pursue a claim against CTCW. There's no basis in the record to support it. There's no corroboration. It's only his internal thoughts. And so, of course, the Florida Statute of Frauds doesn't support that. But more importantly than just the separate credibility issues, the timing becomes critical there. Because, again, that was raised. We first learned of it when we filed a motion for summary judgment saying that CED 2000 did not have the standing to bring this claim for damages that had just been revealed. That's when we were first told, oh, well, CAP 16 assigned the claim to CED 2000. And that's it. We had known that CAP 16 had bought the debt before, but we didn't know that there was an assignment alleged to have occurred. And, of course, that was the first time it was ever revealed. Now,
and so does your argument turn on the validity of the assignment, or do you think there is a basis for reversal regardless of whether or not that assignment was valid?
I think there's a basis on both grounds. First, we don't think that the assignment is valid under the statute of frauds. We also don't think there's any credible evidence, even if the statute of frauds does not apply. We don't think there's any evidence that it occurred because there is no oral agreement of any kind. There's no conversation between two individuals. More importantly, there are policy reasons that require reversal on that basis. As presented to the circuit court in this court, Cap 16 is not subject to the jurisdiction of this court. It does not have to produce documents or witnesses except as a third party. It's not subject to being awarded any, or for us to recover any monetary relief from it if the court were to reverse and render a judgment in our favor. It's not subject to costs. It's not done any of the things.
Certainly, assignments of claims for damages or pursue claims on behalf of other parties are recognized by Florida law. So what about this is different? What about this case is different from the average defendant as assignee of, or plaintiff as assignee of, non-party?
So in every case that I'm aware of, and we've researched this extensively, there are two ways to assign. You can do it in writing, which obviously did not happen here, and we think that was required under the Florida statute of frauds. But even if it's not, then there's still an agreement between two individuals to assign. There's still an oral agreement. That does not exist here. There are not two individuals that spoke to each other. For instance, there's no way to corroborate anything that occurs within this witness's head. It's Brian Spear agreeing with Brian Spear in his mind that he can proceed with this claim. The fact of assignment is also not disclosed in the pleadings. In every in every case I'm aware of where there's been an assignment, the plaintiff says that it comes to court as an assignee of the claims of the other, which actually dovetails back to the first argument. All of this would have been cured with a motion to conform the pleadings to the evidence in the case. That was not made. We laid out for the court and for CED that was a basis on which they could cure these issues. We went through the trial, after the trial, before the trial. At no point was a motion to conform the pleadings to the evidence in the case ever made by anybody. So the record was closed. It was perfected at that point.
And you're into your rebuttal time if you'd like to.
I know you're running out of time. I just really want to tell you, when you come back, I would like an answer to this, and this may take you time to look for in the record. When it comes to continuing damages, when was that request first made in the trial court? What was your response when that request was made in the trial court, if it came out before the order? And where in the record can I find that? Where you argued to the trial court that continuing damages should not be awarded under the law?
Absolutely, Your Honor. And respectfully, we would request that the court's judgment be reversed because it awards damages that were not sought or pled, and we'll reserve the rest of our time for rebuttal. Thank you.
Thank you. Mr. Davenport, whenever you're ready.
Thank you, Your Honor. May it please the court, I represent CED Capital Holdings 2000, the plaintiff below and the appellee here today. I'll try to just focus my arguments on the issues that were raised and the questions that were asked by Your Honors. First and foremost, I think it's relatively plain to us that the claim for damages was pled. There was an allegation that the contract had been breached, and as a direct and proximate result of that breach, CED suffered injury. And this is a claim for general damages, which turned out to be lost opportunity damages. And in the Hutchinson v. Tompkins case, which is 259 South 2nd, 129, the Supreme Court here in Florida back in 1972 specifically held that general damages need not be specifically pled. And they cited to a variety of precedent going all the way back to 1907. So it's been the case for more than 110 years that a general allegation of injury is sufficient for general damages in a complaint, and that is found in the amended complaint. Having said all of that, I'm sorry.
Does your argument turn on these damages being classified as general damages, or even if we disagreed and thought they were more appropriately, if anything, characterized as special damages, that even that was sufficiently pled?
Well, I think it would be sufficiently pled, Your Honor, but to the extent that there was an open question there, it all gets resolved by the joint pretrial stipulation through the merger that occurs at the business court rule, pursuant to the business court rules. And so everything that was identified therein, the damages and everything that had been litigated hotly and significantly, as Your Honor noted, merged into that joint stipulation. And Go ahead. Sorry, Your Honor.
Oh, Mr. Davenport, when we look at the word merger in the joint pretrial stip, do we afford it its plain and ordinary meaning, or do we instead see it as a legal term of art and look to the common law, the doctrine of merger, to help interpret it?
I would ascribe the ordinary meaning to that, in that it all just merges. Everything that had been litigated just ordinarily merges in. I don't know that it would be prescribed the common law legal definition of merger.
Can we go back to damages? Sorry, go ahead, Judge Lasso.
Oh, okay. I was just going to ask, what is your response to the argument that it is a true statement of fact that you were claiming damages, but that it was not any sort of waiver of the pending motions or waiver of any defenses regarding the deficiency of the pleading, and that it was merely just an observation that these damages are being claimed?
I would disagree with that. I think it was, if that was their position, it should have been set forth in the joint pretrial stipulation pursuant to the business court rules, and it was not. There was no reservation. There was no contention that the damages were not being sought, had not been pledged, shouldn't be allowed. And I think, you know, some of the things we heard on initial argument from counsel dives right into this due process assertion that they make. You know, we had an expert that was disclosed. They took that damages expert's testimony. I think most notably on February 25th of 2019, when they filed their answer to the amended complaint, they have an affirmative defense that specifically says that the court ought not award any damages. So they knew damages were at issue because they had been sufficiently pled.
Was the expert disclosed during the discovery period or when discovery was over?
It would have been during the discovery period. I don't recall offhand, Your Honor, if there was a bifurcated, you know, the end of fact discovery, and then we have expert discovery after the close of fact discovery. But the expert was most certainly disclosed during the period of time for which discovery was permitted. And then they subsequently deposed Mr. Dryman.
Is CAP a third-party beneficiary of the limited partnership agreement?
I'm sorry, Your Honor, I couldn't hear you.
Is CAP 16 a third-party beneficiary of the limited partnership agreement?
I would say to a degree that would be accurate, because, you know, it is the parent, it is the sole owner. You know, CED is a pass-through entity that has no bank account, no employees, and it functions through the fact that it has this relationship with CAP 16.
Is there any case law? Is there any case law that would support that theory, that a parent is always the third-party beneficiary of a contract entered into by their subsidiary?
You know, I have not looked at that issue, to be honest, Your Honor. I'm not aware of any.
If CAP is not a third-party beneficiary of the limited partnership agreement, then what cause of action could CAP 16 ever have brought against CED for the assumption of the loan if the proceeding was against CAP 16 versus CED?
I lost you halfway through that question, Your Honor. I'm sorry.
If CAP 16 was the plaintiff in this action suing CED for damages incurred, lost opportunity damages incurred for having to assume a permanent loan, what cause of action could CAP 16 have brought against CED?
Oh, I see. It would have had to have been under a third-party beneficiary theory pursuant to the partnership agreement.
And if that's not available to CAP 16, then CAP 16 doesn't have a cause of action against CED for which to seek these lost opportunity damages. Is that correct?
If CAP 16 did not have a claim against CED?
If CAP 16 does not have a third-party beneficiary claim under the limited partnership agreement against CED, then CAP 16 does not have a viable vehicle to seek the lost opportunity damages against CED. Is that correct?
Did you mean to say CED at the end of that, or CTCW?
CED. No, you're right. I'm so sorry. CTCW, the limited partner.
I'm sorry.
No, I'm better off talking general partner, limited partner, parent. If the parent does not have a third-party beneficiary relationship to seek damages under the limited partnership agreement against the limited partner, what vehicle, what claim could that parent have brought for the assumption of the loan against the limited partner?
Potentially a tortious interference with contract claim because of the contract, the relationship between CED and CAP 16 and CED's contractual relationship with CTCW. I'm not comfortable saying that is necessarily the case, but CTCW knows that CED has a parent-child relationship with CAP 16 because that structure has been in existence from inception of this partnership. Just like on the limited partner side of things, the exact same structure exists. So CTCW is aware of the obligations that CED owes to its parent, i.e. those pass-through obligations. So for example, when cash flow comes to CED, it flows right through and never hits a CED bank account because none exists, and it goes right to CTCW. So if CTCW, as the limited partner, is taking action to interfere with that contract through its parent, then potentially there could be a claim for tortious interference with contract.
But that's a claim that was
But
never
is that
brought.
a liability owed by the subsidiary, or is that a promise to pay? In other words, the cause of action that was adjudicated was breach of contract between the limited partnership and the subsidiary, right? So when the initial brief argues that CAP 16 is a non-party, there's no basis for CAP 16 claim damages in this action, in this breach of contract action, how is that argument not, honing in on something?
Well, I think, Your Honors, one of your last questions, Your Honor, dealt with the fact that Florida law allows for assignments. And so we have an assignment here pursuant to which CED, as the child, is obligated to its parent, CAP 16, to recover not just the proceeds that were advanced, but the lost opportunity cost associated with those proceeds. So the parent comes in and says to the child, look, I'll help you out. Okay, but I'm also going to assign to you the obligation to get this back for me, get me these proceeds. And what
But is there competent substantial evidence that they assigned the obligation to seek the claim, or they were just going to pay up what they received? When you look at Brian Spears' testimony.
Sure, Brian Spears' testimony was unrebutted, totally competent, found to be credible. There was an assignment to receive back the monies that were advanced in addition to the lost opportunity damages that he calculated and identified and presented at trial that were also under the same theory, just in a different manner, Mr. Dryman had calculated. So, this notion that there's no oral agreement is just simply false, because the evidence of record was Brian Spear as the manager of CAP 16 and Brian Spear as the manager of CED testified and said, this is the deal, this is the agreement, and this is why we're seeking these damages.
When was the assignment disclosed? Sorry.
No, go ahead.
When was the assignment disclosed?
When they asked about it. And I don't believe when they deposed Mr. Spear, they asked him any questions about it. They did ask him questions about it at the hearing. And that's the difficulty with a lot of the arguments that I'm hearing from counsel. The fact that they may not have conducted sufficient discovery doesn't serve as a basis to now come in and say, well, I didn't ask about it when I deposed Mr. Spear. And the first time I learned about it is when I asked about it when we were at trial. That's not reversible error.
So the plaintiff had no duty or requirement to disclose the assignment. It was the defendant's duty to ask about it.
Well, the assignment, in terms of the timing of everything. So as you look back at the record, what was going on at that particular time was you have this convergence of activity all being caused by CTCW. CTCW is refusing to assign its limited partnership interests. We have a ticking clock on a permanent loan that is about to come due and mature at the end of November of 2018. And CED has gone to CTCW on numerous occasions and said, look, we need to refinance. And they say, no. It's a common tactic by our adversaries in these types of proceedings. They want to run the clock out on them. And so then Mr. Spear comes back to the CTCW and says, okay, well, if you're not going to do this refinance at these historically low rates, how about if we just extend the note out for 2 years? We can reduce the rate to 4.51. It's not perfect, but will you do that? And then we get litigation counsel coming in and saying, nope, not going to let you do anything. And oh, by the way, we're not going to consent. And if you don't do something about this, which you can't do without our consent, we're going to remove you from the partnership. And so
Mr. Davenport,
CTC.
can we talk specifically about what was assigned? Because this is interesting to me. Cap 16 does not assign a cause of action to CED. Would you agree with that?
Right. It assigned it
just assigns a mere element of a cause of action. It doesn't
Right.
assign a judgment, right? Cap 16 hasn't gone and gotten a money judgment against the limited partner. It assigns a mere element of what typically is built into a cause of action. And I'm struggling to understand, if Cap 16 doesn't have a cause of action against the limited partner, how can it assign just an element of something that it can never build on its own?
Well, I would point to the CP motion versus Goldblatt case, which is 193 Southern 3rd 39. And that's from the 3rd DCA, where the assignment there was for the damages claim, for the ability to go and recover the damages. And that was after
an adjudication, though, and they had moved, if I recall correctly, to be substituted as a party. So it was raised in the context of being substituted as a party after an adjudication.
That's an accurate distinction, Your Honor. And in this particular case, we had an April of 2020 summary judgment decision on liability determining that there had been a breach of the limited partnership agreement, and the court reserved jurisdiction on damages so that the parties could go have their 4-day trial.
Right, reserved jurisdiction on the damages incurred by CED, not CED on behalf of Cap 16 or as a signee of, right?
And under
in terms of the party.
I'm sorry.
Sorry, I shouldn't have done that.
No, it's just that the adjudication was breach of contract.
There was a breach of contract adjudication
for CED. Yeah, for
CED.
CED, and the damages incurred by them, not by a third party.
Well, so CED needs to, through Cap 16, take care of the partnership obligation. So if we go back to what I was saying, there's the $7 million permanent loan that's about to come due at the end of November of 2018. And CED is sitting there with a gun to its head because the limited partner CTCW is saying, we are not going to consent to any extension or any loan. And if you let this go into default, we're going to remove you from the partnership. They know CED doesn't have a bank account. They know CED receives money from the partnership that all flows through to Cap 16. So the only way—
And we understand the argument. We're focusing on the damages incurred. So putting the assignment aside, is your argument then that the assignment isn't even necessary to demonstrate that this final judgment was properly entered because of the relationship between CED and Cap 16, that they were essentially one and the same, and therefore the assignment is nice but not required in order to establish that the damages were properly sought? Or does it turn on it? Go ahead.
I'm sorry, I didn't mean to cut you off.
No. Or is the assignment required?
I would say the assignment is a belt and suspenders approach, and I agree with you, Your Honor, that it's great. It's nice to have. It is factually unrebutted. It is totally and entirely credible as found by Judge Jordan, but it's just an add-on belt and suspenders because the relationship in and of itself prior to that assignment would dictate this result.
Okay. And are you aware of any cases standing for that proposition? It's almost piercing the corporate veil for your benefit sort of situation. So you're separate entities for the purposes of liability, but then when it comes time to seek damages on behalf of either entity, now you're one and the same.
Under this relationship, and well, therein would be the reason for the assignment. So that might suggest then that the assignment is more than just a belt and suspenders approach, because the assignment creates that contractual right for CED to go pursue that for Cap 16.
Okay. In terms of the evidence submitted to the assignment, the testimony was that CED agreed with CAP 16 that any damages it obtained or any money it obtained would ignore to the benefit of CAP 16. If CED is successful in recovering damages associated with the lawsuit, then it would ignore to the benefit of CAP 16. Is there any other evidence of the language of the assignment other than that testimony? Because that's not necessarily an assignment, right? It's more of a promise to pay in that case.
Well, the testimony from Mr. Spear was that it was an assignment, that it was assigned. And he is the only individual, he is the manager, he is the person that
Mr. Davenport, isn't that a legal conclusion about what an assignment is or isn't? He's just describing the relationship and how the money will flow and what the agreement is that he has made within himself.
Well, he provided the factual predicate upon which Judge Jordan at the district court made the legal conclusions that support the award. I didn't mean to suggest that Mr. Spear was offering up legal conclusions. He established a factual predicate for the relationship that exists between CED and CAP 16, and he established a factual predicate for the assignment that we've been talking about. Judge Jordan then made the legal conclusions that that was sufficient to support the award of damages that he provided to CED. Let's see, I have about a minute and a half. Did I cover all the questions and things on that particular issue?
Mm-hmm.
So then I think really the last piece of this is the per diem amount. The per diem amount is something that they, as the appellant, would have a burden to come in and try to demonstrate should not be awarded. That's the only real way to make whole the damages that they caused here, because every single day that passes, there is ongoing harm, and Judge Jordan identified that harm on a per diem basis, and then you multiply it out over a period of days at the time of the trial, and then you have your fixed amount, and then it continues on each day until they will be out of the way so we can refinance.
Mr. Davenport, reading the record, I had trouble figuring out how the continuing damages came to be. When was the first request that CED made for continuing damages in this case? I saw the expert testimony, but when was it actually factored into CED is seeking continuing damages on this per diem basis moving forward after the final judgment?
I believe it would have been in the expert disclosures because they didn't ask Mr. Spear any questions during his deposition about damages. So the per diem, I believe, was identified in the expert report based on the calculations that he did. That's my recollection.
I saw his calculations of per day, but I'm trying to figure out when the request was made that there should be a final judgment, which gives a per diem amount after the final judgment is issued.
Well, the relief that we sought at trial identified the amount of per diem damages that we were seeking. There may have been an interrogatory answer that was given earlier in discovery, but I'm not recalling that off top of my head.
Okay, thank you.
Thank you.
All right, thank you very much. We're out of time. Mr. Griffith, and we'll add 30 seconds on to your rebuttal time.
Thank you, Your Honor. Judge Nardelli, you gave me some homework while Mr. Davenport was arguing, and I can answer your question this way. There's no reference to continuing damages in the pretrial memo. There's no reference to it in the plaintiff's memo of law in anticipation of the trial. I ran a search for the word continuing actually in the record, and the first time I see any reference to it at all is in the final judgment which was submitted. It did come up at trial. It was part of the testimony. There's no pleading. There's no request for relief. There's nothing in this 5,000-page record to suggest that we knew about it before that was happening. Mr. Davenport,
If that's an error that appeared for the first time in the final order, was a motion for rehearing filed on that point?
It was not a motion for rehearing filed. There was not. Instead, we filed a notice of appeal because, again, as we heard testimony a second ago regarding what claims were made, we heard a lot about the fact there's this reference to injury or they knew we were damaged, but that's all under the claim that we failed to transfer a limited partner interest to the general partner. There's not a hint or a whisper of any allegation anywhere in either complaint of any type of claim associated with a failure to consent to the refinancing, which is what the whole trial was about. It's what all of our motions were about that were contesting it. Your Honor asked Judge Nardell, I believe it was you, when did we first find out about the assignment? And the answer is July 20th of 2020. It's not because we asked, it's because we moved for summary judgment. It's on page 34, 46 to 47 of the record. We moved for summary judgment, said CED 2000 did not have standing. This is after discovery closes, and they respond with an affidavit from Mr. Spear that says it was always the understanding that CAP 16 would have CED 2000 pursue claims on its behalf. It doesn't even talk about an assignment of when it took place. It said that any claims and rights to recover would have been assigned as part of that, but it doesn't say when. And I think several of you actually noted correctly, there was really no claim to be had. If there was tortious interference, let's pretend for the moment that that's the claim that could have been pursued, that's not in the complaint. If it was some other type of derivative claim, that's not in the complaint. If it was some type of damages of any type, that's not in the complaint. All of these issues draw back to the fundamental proposition that these issues are not presented in the complaint. There's no request for damages anywhere in the complaint, and notwithstanding our objections, it moved forward. We heard Mr. Davenport acknowledge that part of the assignment included that if money was actually collected, that it would get paid back to CAP 16. That, by definition, means that the transaction has to take more than a year to perform, which requires that the Florida statute of frauds become implicated, and it has to be in writing. It's not writing.
What is your response to the cases that, or the finding rather, that lack standing to challenge that agreement on the basis of statute of frauds?
Well, I think any party that is being asked to oppose a document, which in this context, they're taking the position that they have standing to proceed. I believe we absolutely have the ability to challenge that standing, whether it's through statute of frauds or otherwise. In the absence of that, no party could ever bring a standing objection when we're dealing in a contractual situation, or very rarely could they, because in that instance, the defendant would just be stuck saying that, you don't have standing to proceed, but I'm not allowed to make that claim. I'm not allowed to defend myself, and we could end up defending actually two separate actions for the same thing. Judge Sasso, you asked the appropriate question, what case stands for the proposition that the parent can sue on behalf of the subsidiary? The answer is there is no case. There is no case in Florida, there's none cited here, and there's certainly none on which CED could rely at this point. And so I respectfully see that I'm out of time. I'm happy to answer any other questions that the court may have, but we would request that the court reverse in this instance and remand for further proceedings.
All right. Thank you both. We will adjourn.
Thank you.
Thank you. Have a good day.
Thank you.